Got a few more buttons to press here to get things dialed in, and we can kick off this discussion. So welcome to our monthly discussion on with elder law attorneys. And today we have two elder law attorneys, Richard Abraham and Elizabeth Gray. And let's first get to know the two of you a little bit better. Elizabeth, if you want, ladies first. So if you want to go first here and tell us a little bit about yourself and the practice that you work with.
Sure. I'm going to start by saying that I was always intended to be a musician. I grew up in a musical family and I played the violin. When I went to college, I got into the Binghamton Symphony and the BC Pops orchestras. And decided that that was not the life for me. It's a hard life. So I decided to become a paralegal after I graduated from college. And the lawyer I was working for kept saying to me, "You should go to law school." And this was in the 90s. And I kept saying, "I am not going into that kind of debt," which I understand has sort of quadrupled since that time. I had a mortgage, I was married, I didn't want to go into that debt. So he mentioned that in Virginia, you don't actually have to go to law school to become a lawyer. So I am a law reader. I didn't actually go to law school. I mentored with an attorney and then took the bar exam and passed. So that's sort of how I became a lawyer. And my first job was with a solo practice attorney that had been practicing for about 30 years when I started working for him. And he had told me that I need to try a bunch of different areas of the law to see what it is that I like. And so I did. I tried all kinds of different cases, and I had one case involving this elderly gentleman, and I fell in love. I thought, oh my God, I love working with this guy. He was terrific. Just finding out about his past and where he'd been and how he got where he was. And then having to deal with his children and how to protect him from abuse and taking advantage of him. So I left him, the attorney I was working for, and started working at a boutique elder law firm and have been ever since an elder law attorney.
I love it. You know, I knew about the law reader, and that's a unique aspect of your resume, but I didn't know about the music school. So this is, I learned something about you, and I thought I knew you pretty well. So thanks, Elizabeth, and it's great to have you on the panel today. And then Richard, tell us a little bit about yourself and what led you to this unique practice of law.
I stumbled into elder law, actually, when I was younger. There was that constant yin and yang between I want to be a physician or an attorney, and the attorney won out. In my first 5 years of my career, I was actually an appellate tax attorney handling state and local tax issues, was accepted at Georgetown to get a master's of law in taxation, and thought, yeah, you know, before I really get pigeonholed in tax, better find out if I love it enough and am passionate enough about it to just work in tax law. And I decided that really wasn't the arena I wanted to spend the next 35 or 40 years in, and moved back to Maryland where I grew up and went to work for a gentleman that did a really high volume of a component of elder law called guardianship, and then eventually was an associate at other law firms, and finally went out on my own in the late 90s and merged my firm with another firm, initially just to handle guardianship matters and then firm-wide. And the entire time I've been in Maryland, I've always been working in elder law, estate planning, estate work, and we've branched out now to also assist business owners, because what we found is that the business owners and the estate planning attorneys, so the business planning attorneys, they weren't talking to each other, and their documents were doing this, which is a problem. The reason why I enjoy elder law is it's really a privilege. I get to assist seniors, their families, and their friends, and ease their burdens and help make their lives more comfortable. The goal always is to allow them to continue to live at home as long as is possible and as long as it's medically feasible. And that, in a nutshell, that's really why we do it. I get a lot of satisfaction out of being able to help people, and most attorneys don't get to say that day in and day out. That we're helping people every single day.
That's
And
right.
that's really why I love it.
Before COVID, we used to get hugs from our clients.
We did.
Not now. Elbows.
That'll happen sooner, I hope. Now, the just so that the audience knows, you guys are obviously in two different practices. And Elizabeth, what I imagine with COVID, which we're going to dive into, there's a lot of virtual legal advice that's being given, but what is your primary geographic practice area for your practice, Elizabeth? And then I'll ask Richard the same thing.
Sure. My office is in Fairfax, Virginia, and I do all of Northern Virginia. We have another office in Leesburg, so I can meet with clients either place. Lately, I've been doing mostly Zoom consultations with people.
Great. And Richard, your practice is primarily
have offices in Baltimore and Harford counties, which Harford is north of Baltimore, a little northwest of the city. And the practice primarily focuses in all of central Maryland, but I've handled matters in every county now in Maryland, particularly estate matters, so probate.
Right.
In every jurisdiction, at least 2 estates everywhere, but most of the practice is in central Maryland.
Great, excellent. Okay, so the we've already got questions that are coming in, and we've got those that one list or audience members question that came in before the event even started. But I want to kind of just dive into talking about COVID a little bit and how that's changed both of your professions and practice. I know you, Elizabeth, you mentioned no more hugs, but also some guidance for our audience on this post-COVID world and some things that may have changed in relation to the profession of elder law. Elizabeth, you want to go first on that?
Sure. So one of the most significant changes that I've seen are the uptick in guardianships. Before COVID, my practice sort of goes in waves of estate planning, special needs, elder law, but lately I have had an enormous amount of married people where one of the spouses is incapacitated and never executed estate planning documents. So there's no power of attorney, no advanced medical directive. And I think prior to COVID, the spouse that didn't have any issues was able to cover for this spouse. But because of isolation and not having the supports in place before COVID, during COVID, the spouse without issues just can't hack it anymore. And so I'm getting calls from the spouse or the adult kids that this is a real issue and we don't know what to do.
How about you, Richard? Any thoughts, or you care to kind of jump on that topic?
Yeah, COVID really reinforced certain principles that we practice law by, and it's shown all of us that false notion that I may never become disabled, I'm never going to die, those are incorrect. It's shown us that the what ifs do in fact happen, and they can happen in the blink of an eye. And as a result, we're also seeing an uptick in guardianship. We're seeing a serious uptick in stressed out clients that need everything done yesterday. And we have loved ones calling in, I need to get power of attorney over my dad or an advanced healthcare directive. And, we'll try to talk to dad, and dad unfortunately is no longer competent. And we're seeing more and more of that. you know, our job is really to make those difficult conversations easier. And instead of those being in person, at least initially, those are always in a virtual or conference or over the phone. I'm looking forward to being able to meet with people in person again. But right now, the only thing we're doing in person is signing conferences on the documents. So it's changed the way we practice. Moving forward, you know, if I could say, you know, if I had one thing I could wave my magic wand in Maryland, Virginia, and across the nation, is that people wouldn't delay, they'd get their planning done. It wouldn't bother me a bit. I don't know about you, Elizabeth, if I never had to work on another guardianship, I do it as a favor to the citizens of Baltimore and Harford counties, but if I never had to see another one, it wouldn't bother.
Yeah, they're not fun.
Yeah, they're not fun for anyone. They're not economic, and they're very stressful for our clients, both monetarily expensive, time management expense, and then the actual emotional stress of, oh my God, I got to go to court. At least in Maryland, and I don't know Virginia law concerning this, but it is a formal court proceeding with a judge and sometimes a jury, and it can be stressful for the client.
Is Maryland still having these hearings remote, or?
Yeah, they're still remote, although the courthouses are slowly starting to open. Jury trials, I believe, are going to recommence in the next couple of weeks. I'm not sure. Each county is going to open up their courthouses a little differently. In Baltimore County, I've been told at least that guardianships for the short term are going to continue to be virtually unless it's a contested case.
Great. Well,
In Virginia.
Richard, you brought up planning, and this relates to a question, one of the questions that we received before the event. And for all of you that are typing in your questions, this is great. We're going to get to them. I just want to make sure that we get these two series of questions that came in before the event. And this person is very organized. They're talking about disability planning, and they ask, what should I do to avoid a crisis? What happens if the crisis occurs first? And lastly, they say, should I add my child's name to my assets? Would you guys like to comment?
We hate that. No,
Yeah,
don't add your child.
Elder law attorneys and planning attorneys hate that.
Adding
your
says
child's name.
Okay, so just to kind of clarify that, because I think that is probably a very common, it sounds like it's a common request you get, is what is the methodology around that? Why do you guys, what is the alternative to adding a child's name to assets?
It's actually doing two things. One, having a complete, properly drafted power of attorney and not some piece of junk you bought down at Staples. In Maryland, the case law says if you don't specifically state an enumerated power, your agent can't undertake that. So they're lengthy documents today, and they need to be precisely crafted to meet your needs and not checking off all these boxes. Those don't work in Maryland any longer. And then for the healthcare, having a healthcare directive. And if those are properly executed and followed, that's going to prevent guardianship of property and person. And then concerning adding a child's name to an asset, the better method is to add the child to your account as a power of attorney. And then you could also put them on there as a beneficiary. The latter action would avoid probate, but if you put them on there as an owner, they own it with you. And I get these calls every year that I added my son to my bank account. He has a new girlfriend, and they took $6,000 and they're in Hawaii right now. What do I do?
Mm-hmm.
And there really isn't a whole lot you can do. They're an owner. The bank can't deny them access. Or I added my son. My son was in a car accident, and the person he hit sued, won. The damages are over the policy limits, and now they're trying to take part of my account to satisfy the judgment. An owner means owner, and it's available to potentially pay your son's debt or your child's debt. It's available for them to do whatever they choose to do with it, and it does not save or shelter the asset from Medicaid. It's available to pay your cost of care in a nursing home. So Elizabeth, tell us about Virginia, please.
Same exact Virginia. Virginia we're part of the Uniform Power of Attorney statutes, and if it's not expressly provided for in the power of attorney, you can't do it. And we oftentimes have to do a guardianship because somebody downloaded a form and it doesn't do what they thought it should do. And that's always heartbreaking, because if they had just done it correctly before the parent had become incapacitated, we wouldn't be at this point where we're going to court and saying, look, they downloaded this power of attorney, it doesn't have X, Y, or Z in it, and now we need to get that power from the court. And then, like Richard said, with the adding the child to accounts or to property, the parent's making a gift for Medicaid purposes in a lot of instances, and it's subject to that child's creditors. And what if they get divorced and that account gets brought in? It's just a bad idea. And then if you add a child to an account, like Richard said, they own it. And in Virginia, the presumption with real estate is that they own 50%. So Richard and I probably see the worst in people. We don't see the people that do the right things, but I can tell you we've seen some pretty horrific cases of children taking advantage of a parent naming them, putting their name on an account or on real estate.
We have as well, and I like to think the best of everyone, and until their actions show me that I can't do that, I will do so. But we have seen, you think about what can and may have occurred over the last 30 years. I've encountered a lot of it. Extreme amounts of theft, misuse of funds, physical and mental abuse. And the list just goes on.
Well, actually, we've got some comments that relate to some of the things that you've just said. So first, I want to address Monica Perry's comment. She says, I need a medical directive and a POA desperately. So how does one go about doing this the right way? Obviously, Monica, the first step is tuning into a discussion with two elder law attorneys. So what advice would you have to somebody that would make a statement like that?
Elizabeth, you go first.
I would say make an appointment with Richard or myself to talk about what you need in that power of attorney. And I'm sure Richard does the same thing, that I like to do comprehensive, robust estate plans that are defensive in protecting this person from having to have a guardianship or having a child take advantage. So I would make an appointment, and we're going to need to see everything, what your estate consists of, because we're going to be providing you advice on those assets. So that's why we need to know that, what your family dynamics are, what your relationships are. We need to know all of that in order to help you make the right decision on what type of estate planning you need.
Okay, and now because I know this question is going to come later, okay, and you both can sort of comment on this, is like, because I talk to our readers every day, and it's sort of like, I can't afford an attorney. Attorneys are expensive. I've heard horrible stories about how expensive it is when I call a law firm. Any sort of words of wisdom that you might offer somebody that's saying, I need a medical power of attorney, but I'm scared how much it's going to cost. Any thoughts on that?
If you're the type of individual that likes to buy $5 shoes and thinks that they're comfortable and they're never going to hurt your feet, and they're great because they're $5, there are avenues available to you to still get your planning done. But if the ultimate goal is to get a comprehensive plan that looks at all of the different things that you need to be educated about, and then helps you define your goals, as well as provide protection for yourself, your family, and what you own, then you really do need to consult with an elder law attorney. In our firm, we charge flat fees for planning. Not every firm does that. Some of them are hourly. And we try to maintain the cost as low as possible. Yes, it's going to be more expensive than using one of the online platforms, but it's not tens of thousands of dollars either.
Mhm.
I think the most expensive estate plan ever put together was, but this gentleman was worth many millions of dollars. So he needed a lot of trust work done. And it was expensive, but he also needed that form of planning. For the average person that doesn't need tax planning done, that may not need trust planning done, it isn't as expensive as you think it is. But it's a free marketplace, and you can always call and determine what firm is going to best fit your needs. The things that you need to inquire about, though, are no different than any other aspect of your life. Does your law firm regularly engage in estate planning? Another reason we sometimes have to file guardianships is we see other law firms that, I'll just pick one out of thin air. They can specialize in appellate tax work or bankruptcy work or injury work, and they're drafting planning documents as a favor to their client, and they don't cover the client's needs in the event of disability. And so it's almost like we're starting from scratch. So you have to ask, do you do this stuff on a regular basis? How are my documents reviewed? How does this work? And those plans do more than just, they're not simple. They help you plan for physical and mental disability. They provide for you and your loved ones. They provide instruction and direction to your family, both in the event of disability or death. They help plan for your children. They help plan for people with special needs. And I was talking to Elizabeth earlier, and she has a family member with special needs. And we were both commenting that having gone through the what ifs in life has made us better attorneys. It allows you to, on occasion, plan for your retirement better, to create a succession plan for a business. And it really just depends on what your needs are. So I'm not a big proponent of online platforms unless someone really wants the least expensive thing available out there. And if someone can't afford it, I want Elizabeth to say, we'll offer, no interest payment plans for like 90 days. We do that to try to accommodate clients that, it's more important that the client can eat than just pay me. And we get it.
Great. Yeah, I just wanted to make sure that I brought that up. Man, we're getting a ton of questions coming in here, so I'm going to dive into some of these. And actually, this is a person that's done a power of attorney. Karen, she's done a power of attorney, medical executor for my mother, who's now highly disabled with mild dementia. I plan on moving her to a wheelchair accessible house on my farm. My brother has been out of the picture for years. He is number 4 on the power of attorney designees. If I'm incapacitated, what, if any, duty do I have to inform him? So talking about sort of family members there, he's low on the list of designees, but she's obviously a little bit concerned if something happens and he's the decision maker. Thoughts on that?
Well, I think that lay people oftentimes don't understand what their duties are and what their job is as the agent or a fiduciary. So it would be a good idea for her to come talk to one of us about notifying the person when it's time for them to step in, and letting them know what their job is as the fiduciary. So it's hard to say just without providing legal advice over the webinar to to tell you what to do, but I would suggest talking to your lawyer who drafted the power of attorney, and to figure out what happens if you become incapacitated and you have a family member that's estranged but named in the document. I am a big proponent of picking the right person for the right job. I don't know that enough non-elder law attorneys talk with their clients about who they're picking. I mean, why would you name somebody that's estranged as an agent with authority to make your financial decisions? But I'm still shocked by people naming adult children that are not good with money. I mean, if that child can't balance his or her own checkbook, believe me, they will not be able to balance your checkbook. And yet we see that all the time. And going back to Richard's comment about the price, I think that there are the Honda dealers and the Mercedes dealers of estate planning documents all over the place. And if you can't afford the Mercedes, well, you know, you can probably find a good Honda that's just as good. But there was a recent Superior Court of Pennsylvania case regarding a power of attorney that somebody downloaded for his mother. It was a springing power of attorney. That means that it wasn't effective immediately. But even though it was springing, the son used it right away. And he ended up selling mom's property. But meanwhile, she had given the property with a deed to her other son. And it went to court and it went up the court system. And I cannot imagine what those legal fees would have been at the end of the day if they had just gone to a lawyer and had it done initially. It may have been a little bit more than that downloaded form they got, but they sure wouldn't have had this problem and having to go through the Pennsylvania court system up to their superior court.
Here's Karen actually typed in a little follow-up to that question. And she says, actually, my concern is he can make any claim against me for moving her. So he's on this document 4 down. She makes the decision to help mom move to her home, and the impact that another family member could have on that.
It's still another reason why you engage planning and elder law attorneys to have this work undertaken. In all likelihood, such an action would not be successful, but she needs to understand that there's nothing that either one of us can draft in Virginia or Maryland, respectively, that's going to control what another sibling or child does. We can't control their conduct. So could he potentially try to go to court? Sure. Will that action be successful? More than likely not, as long as you're observing what Maryland calls the reasonably prudent person rule. You know, is it reasonably prudent to have your mother receiving care where she's currently residing? Is it reasonably prudent for you to manage her affairs in the manner in which you're doing it? You know, for us as elder law attorneys, our standard is higher. But for you as a layperson in the community, you're going to be judged on reasonably prudent.
Okay, I got a Medicaid question. I know these have come up a lot on these discussions. And Susan asks, if you do not have cash receipts for withdrawal in 2017, can you be denied Medicaid in Montgomery County? My parent has dementia. So
Maryland will require you to provide information pertaining to any withdrawal or any check that was written on accounts that are part of that application when that withdrawal or check exceeds $1,000 and it's not a normal monthly occurrence. So every month I'm paying a mortgage, the amount's $1,200. But all of a sudden you withdrew $17,000 or whatever the amount is, there is a possibility that it will be denied for a while, yes.
Okay.
But without having all of the information under roof pertaining to that application, et cetera, it's really hard to answer that question precisely in a vacuum with with a snippet of the information. But the
Okay.
simple answer is, yeah, there's a chance it's going to be denied.
Okay.
Remember that Medicaid can look back 5 years to see what you've done with your money in your estate.
And they will.
Okay. And then this is a question from Ken Silverstein. There's a lot of, we do have people that are, you can see by the questions, people that are planning for themselves, but we have a lot of professionals that are on these calls that are trying to partner with elder law attorneys like you. And it says, how receptive are you to providers reaching out to you or even just dropping information by your office? Or how do you prefer to be contacted to establish a connection with a referral source? You know, just your personal preferences.
Well, now that we're in COVID and I have not been fully vaccinated yet, I would prefer the drop off or a Zoom meet and greet. But in the old days, oftentimes we would go grab a cup of coffee over at Starbucks with somebody to meet them and learn a little bit more about how they practice.
For me, it is exactly what Elizabeth said. I have been fully vaccinated, but it's to keep the staff in the office safe and to keep that individual safe. We would prefer a Zoom meeting right now. In the old days, 2 whole years ago, we would do a meet and greet at a mutually convenient spot and have a cup of coffee. But it's got to be a good match in terms of the philosophy of practice. So I'm not against meeting with anyone, but I also will or will not hesitate. I misspoke. I will not hesitate. So I will tell you if I think it's a good match or not.
Great, great.
Because the personalities and the way we practice as elder law attorneys and the way some other professionals practice in their own industries can vary and be different. And we have a slightly different standard that we have to adhere to.
Let's see, this is actually, Martha Cooper has a good question that I had too, is what role does the jury play in a guardianship case? You had mentioned earlier that there were juries involved, and I didn't realize there were juries either.
I've had one jury trial. I've also gone and sat in on another one in a guardianship. And the role of the jury is they're replacing the judge, and they become the person that is going to decide whether that person is disabled or not. So whether the alleged disabled needs to have a guardian appointed or not, they're stepping in and becoming the trier of fact, so to speak. And it's their responsibility to make a decision based on the evidence presented, whether the alleged disabled needs a guardian or not. And in Maryland, the alleged disabled can always ask for a jury trial. Most of them don't. Pardon?
Richard, is it automatic when you file a guardianship petition that you will have a jury trial, or you have to specifically ask for it?
It's asked for, but it is automatic. If I'm court appointed counsel, so the attorney that the court appoints to represent the disabled adult, I have to waive their right to a jury trial during the hearing.
Okay. So in Virginia, it's going to be a bench trial, meaning it's just going to be before a judge unless the respondent, the alleged incapacitated person, requests a jury trial. So
Okay.
I've only had one occasion where counsel for the alleged incapacitated person requested a jury trial, and the case ended up settling before. So I've never had to do one before a jury.
Great. Here's
an experience.
Oh yeah, Perry Mason. It's probably not what most elder law attorneys expected they would be doing. Let's see. Elaine asks, and this is a good one related to some of our conversation, is it okay to add a child as a second person access to a safe deposit box? Like, is there a risk? What are the risks in that? I'm assuming, like, if you've got insurance files and things like that, in that safe deposit box, that might not be a bad idea, but I'm not sure.
Well, you've also potentially have things like expensive jewelry
I was
and
going to say that.
coins and other valuable possessions that can be in that box. Some people store a lot of money in their boxes.
Yeah.
And if you add them as an owner, they can enter and take out and do with what they feel they have a right to do with what's contained in that box. I would rather them be on there, just my 2 cents as an attorney in fact, present it to the bank. And if their legal department may have a separate form, they're not supposed to have these any longer, but that would give you access as an attorney in fact. But in those instances, don't be surprised if branch personnel goes with you into the room while you examine the box, because you're not an owner.
Right. Okay, man, we got tons of questions. I hope we can get through them all here. What happens to life insurance policies if someone goes into a nursing home? Does the nursing home cash them out before Medicaid kicks in?
That's probably different in Virginia than it is in Maryland. In Virginia, in order to, as a single person, become eligible for Medicaid, you can only have $2,000 or less in assets. If the life insurance is not term life insurance, then there's a cash value to it. And that cash value goes to that $2,000 or less of assets. Medicaid isn't going to cash it in. The nursing home isn't going to cash it in. You have to cash it in. You get the money and you get to spend it. So Medicaid doesn't take anything. You're just not going to be eligible until you meet their financial criteria.
Maryland's a little bit different. The ceiling on asset value that the applicant can own for nursing home medical assistance is $2,500. But there's a different ceiling and cap on life insurance that has cash value, and that's $1,500. Once again, the nursing home is not going to cash it in. The state isn't going to cash it in. And one of the things we typically recommend is meeting with the funeral home of your choice and potentially turning that policy into an irrevocable prepaid burial trust to pay for your burial or cremation. But if you leave it as let's say it has a $10,000 cash value, you're, as the applicant, and let's say you're single, you're going to be over scale, which means you have too much resource value available that's allowed to be used to pay for your care, and you will not receive benefits for a period of time until you've spent that money properly. That doesn't mean giving it away as a gift, but on things like your care.
Jan Call asks, in real estate, is a transfer on death deed a good idea?
It depends. Richard, do you want to take this one?
Sure. In Maryland, one of the forms of planning we do is it's called a life estate deed, and there are two types: with and without powers. With powers, you maintain the ability to conduct further business. Without, you give that up, and the act of giving up one of the incidents of ownership means you've created penalty for Medicaid. So it has to be done carefully. It can be done as purely a mechanism of estate planning to avoid probate on the real estate, but it has to be done as a component of an overall plan to ensure your needs and your goals are met. So I don't endorse just randomly creating what is in effect a beneficiary on your house without knowing the pluses and minuses, the positives and negatives of doing that, which once again is why you consult with a planning and elder law attorney. I know we keep beating our drum about that, but these questions are really illustrating that these are not simple matters that the people that are typing in, and there aren't simple answers. These are complex.
Yeah.
And they have to have complex thorough explanations provided to the client with a full examination of their goals and what they own and who they want to benefit when they pass away, etc. So these aren't simple consultations any longer.
No, I didn't even know a deed like that existed. So
Okay.
this is a good one that I think a lot of people are thinking about. If I have a POA, power of attorney, and healthcare directive in Virginia, and then move to another state, do I need to redo all my documents?
I would say it's not a bad idea to meet with an attorney licensed in the new jurisdiction and have them look it over to make sure there are no issues in the new state. I do that all the time. And if I see the power of attorney and I think it's going to be perfectly okay here in Virginia, I'm happy to say that and save the client a lot of money and expense. But if it's not, then I'm going to recommend that it get redone.
And it's important to really understand that some of the things in terms of how we draft vary by state. Every state's supposed to give full faith and credit to each state's documents and laws, but it can be a nightmare. So the other piece is, how comfortable are you with those documents? How old are they?
Yeah.
You know, let's say you moved from Virginia to Maryland, and in Virginia, you had a power of attorney and healthcare drafted 25 years ago. And we're more than likely going to recommend that they get updated. So, you know, it's the age of the documents come into play. If it's sufficient and meets all the little foibles that Maryland presents, yeah, I'll tell you that as well.
All right, got another question that I think one of the responses is going to be, it depends, but it's a good one. This is the first part of it says, can you name your living revocable trust as a beneficiary for bank accounts and life insurance benefits? And then they also add, could you also discuss pour over? Is this a clause or instruction on a living will, or is this a pour over testamentary will or part of the will? This is confusing, but important to try to learn and grow and understand. So I'm totally confused. So I'm interested in hearing how you guys will respond to that.
Okay. There are a number of different ways that probate can be addressed. And one of those ways is called a revocable living trust. They are not Dr. Kilmer's swamp root elixir, in my opinion, where they're going to solve all of the evils that are out there where probate may or may not be concerned. In Maryland, probate doesn't have to be this long, drawn out, horrendous process. But revocable trusts can be named as a beneficiary, but typically you're transferring your assets into that trust already. And that's one of the bugaboos that we see all the time. Client titles in, can you look at this? Okay, you created this trust 6 years ago. Did you transfer your assets? Well, no. Did the other attorney tell you to do that? Yes. Why didn't you do it? I just never got around to it. Well, guess what? You just paid to have something drafted that you're not using and receiving benefit from. So, you know, it's, once again, it's not a one size fits all. We do draft revocable trusts, but we draft them once the client has been educated in terms of the positives and the negatives. And the pour over will is for assets that are not in that trust, that haven't been titled, so that at your death, they get poured into the trust. I think that's the easiest way to explain it. How does Virginia view that stuff, Elizabeth?
Same way in Maryland. So if the asset is not owned jointly with rights of survivorship,
yeah,
or there's no beneficiary designated, then that asset will go through probate.
Okay.
And the pour over will is really just a safety net to pick up that asset and pour it into the trust. So there's
Correct.
still a probate for that asset, but the probate is, the court is going to want that asset to go directly to the trust.
Yeah, so, and that's correct in Maryland too. The will is going to then take over, because while you were alive, John or Jane Doe client, you didn't actively take the benefit that the trust provides by the horns and undertake the actions necessary to avoid probate.
And then that's called trust funding. And it's a
Yeah.
huge part of what I see elder law attorneys do a better job in explaining to the clients how to do the funding,
Yes.
how to get those assets in there, and trying to make sure it gets done. It's a royal pain in the neck. Clients
It is.
want to do it.
It's a royal pain in the neck, but almost every state has them. Some states, probate is a nightmare. You know, like California and Florida, probate is a nightmare, but it's not in Maryland. And I haven't heard horrible things coming out of Virginia either.
It's not a horrible thing in Virginia. It just takes time and costs money.
Yeah.
It does here too.
So interesting. We got a few questions related to debt. I'm going to try to consolidate them here.
Okay.
One that's rather intriguing is, what is the statute of limitations on timeshare property that you haven't used since 2015? And apparently this is a timeshare in Aruba, and I live in Montgomery County, Maryland. I imagine that timeshares are a very interesting thing that you guys deal with. I'm curious, any sort of feedback on that?
Well, I think it's in Maryland. So Richard, I think you're on the hook.
Thanks. Interesting phenomena is that on the open market, timeshares don't have a tremendous amount of value. That's the first piece. The second piece is, and we've encountered different things sort of along these lines, there isn't going to be a statute of limitations because it was purchased under a contract that gives you a certain right to use that timeshare 1 or 2 or 3 weeks a year. And for that benefit, you either pay a monthly fee or an annual fee. And just because you haven't used it doesn't mean that the contract still isn't in full force and effect.
Well, you know what?
The same kind of things that, the important piece to remember is that if the timeshare is in Aruba, Aruba's laws may control. And we encounter that in estates that own stock, where the named beneficiary on the account died and there's no contingents named. And it's the laws of the state of the jurisdiction where that account was opened. So South Carolina, branch of the national brokerage concern, but Missouri's law is controlled in terms of how that asset would then flow when all of the originally named beneficiaries predeceased the decedent. So you have to really read those contracts carefully. And my advice to you is to read it. It probably has a clause in there that says if there's a disagreement, this is how that disagreement has to be handled, and you're going to need to undertake that action. It may be mediation. You may need to hire counsel in Aruba. I don't know.
Yeah, and I imagine a lot of these timeshares are being passed on to the next generation, and so the estate might be obligated to the terms of those contracts after somebody passes away. This kind of ties in. This is another sort of obligation. It says if a parent has a parent plus loan and they pass away, is the adult child or surviving spouse responsible for the loan? So, you know, when we talk about passing on our estates, we oftentimes think of passing on this pot of gold, but we all have debts, or many of us have debts, and those may be kind of shocking to the heirs that are being passed on.
I've never heard of a parent plus loan before, so I don't really know what that is.
Neither have I.
If you
I wonder if it's like a student loan where it's the parent
co-signed.
Yeah, that's what I'm thinking. That it could
Okay.
be.
Normally, for the individual to be indebted on a loan, they have to be a party on the contract. Debt that survives the individual is then owned by their estate And at least in Maryland, there is a hierarchy of paying debt. So you don't drop down to class 2 until all the debt in class 1 is paid. And then you can look at 2. So as an executor, you have to be careful that you're not breaching the duty you owe to both the people inheriting and to people that may properly file what are called claims in the estate. Because if you do, you could be personally liable for breach of duty. I do not recommend you just start paying debt randomly without consulting with an attorney, because once again, you may be making yourself personally liable. Here's a quick example. Dad owned a Visa account and I paid $25 on the account and there's still a $3,000 balance. Well, guess what? At least in Maryland, you're now responsible for the remainder of the debt because you started to make payment on Dad's account. But don't do that. Dad's estate now owns his debt. He died.
Okay. All right, let's see. We're nearing the top of the hour. I think this is a good question to kind of wrap things up on. It says, can you explain the difference between trust-based estate plan and a will-based estate plan? Can you change from one to another if the life circumstances change or the assets change?
Well, I don't know that you would necessarily want to change from one to the other, but a trust-based estate plan means that your main vehicle for transferring assets at your death is the trust rather than the probate and through the will. And it's a better option. Like Richard said, a trust avoids probate. The assets bypass probate. It's a better option during any time that you might be incapacitated if your trust is fully funded. And that's because financial institutions hate powers of attorney. There's so much fraud with powers of attorney that they would probably prefer the trust-based estate plan. A will-based estate plan means that your assets are intended to go through your will. And there are people that would prefer a will-based estate plan. There may be some reason why you want court supervision of the distribution of your estate. So those are my 2 cents on that.
And sometimes you may have both, for instance, or the trust may be contained in your typical estate plan if you're very wealthy and tax planning's been done, or if you want, say you have a special needs child and you want to leave money in a special needs trust for him or her at your death, as differentiated from creating a standalone special needs trust for that child's benefit while you're alive. You can also create it through your will. But there's 150 flavors of trust. It's sort of like going into the ice cream store. They can be for tax planning, special needs, second marriages. There's just a lot of different things that trusts address today. So without having more information based on that consultation, it's hard to really say which one is best for the individual. And the goal of the planning and elder law attorney at that point is to educate the client as to what's available to meet their goals so that the client makes decisions that they're comfortable with and happy with.
Great. Well, okay, if you guys don't mind just staying on for one more minute, another question came in and then this is it, no more. Whenever I say it's the last question, people start typing. But this one says, after a divorce, if the court transfers debt to the other spouse, how does that play out when creditors come after the spouse who courts have decided does not own the debt? Kind of a confusing one there.
You need to go back to your divorce attorney and discuss that, to be honest. I don't know the answer to that, and I don't even want to venture a guess because it wouldn't be fair to whoever asked the question. But this is another really good example that law today has become very boutiqued and specialized because it is so complex.
Yeah.
The day of opening the phone book and picking a lawyer that works he or she in 98 areas of law, that's pretty much over, even in smaller communities. And it's why it's so important to ask those questions. What areas of law do you work in and day out?
Yeah.
So please do yourself a favor. Do you know the answer, Elizabeth? Because I just don't.
I don't, but I started out doing domestic relations, and my recollection is that lots of times when the court moves debt to one spouse or the other, you're just indemnifying the spouse or agreeing that if a claim arises, you will step in and
Okay.
do something. And so it doesn't really relieve you of this issue of who's going to pay this debt when the creditor comes calling. And lots of times you're signing something that you're jointly and severally liable on this debt. And that means they can go over whoever they want.
Sure.
So,
Yeah, and I think that's a logical, really good answer because, typically courts aren't going to rewrite a contract. That's something that makes judges' skin crawl.
Yeah.
We're not going to do that. You entered into the contract, you're bound by the terms. You may have a separation agreement that says the wife pays this debt, the husband pays this debt. We're going to say that our court order is taking notice of that separation agreement. But at the end of the day, you both signed the contract, and that creditor can more than likely seek payment from both of you. But you still should talk to your divorce attorney.
Yeah. And more than likely, but it's one of these agreements that we signed that didn't realize what was spilled out in it, until you're put in a situation like that. Well, this has been great. I love these discussions, and the two of you are great together and really have some great energy. Just for everybody in the audience, I know people have another Zoom meeting to get to, but we do record this. We record it to podcast. I'll follow up with everybody with contact information for both Elizabeth and Richard if you'd like to reach out to either one of them. And I want to thank you for spending time with us today, and look forward to seeing you and our audience out there.
Thanks for inviting me, Steve.
Yeah.
I really appreciate it. I had fun.
it was fun. Thank you.
Nice meeting you, Elizabeth.
Nice meeting you, Richard.
Take care.
Take care. Bye-bye.